Good evening, everybody. Attorney Greg Lake, welcome to the Entheogenic Esquire YouTube channel and podcast. As advertised, tonight we're going to be discussing the preliminary hearing in the Tyler Robinson case and whether the state of Utah established a sufficient foundation for the alleged text messages between Tyler Robinson and Lance Twiggs. I'll move my mic a little bit closer. More specifically, we will assess whether the state presented enough evidence for a reasonable juror to believe they are indeed authentic, as that is the state's initial evidentiary burden if they plan to get the text message evidence in front of a jury. And again, we've discussed that legal standard before, and we have discussed, at least preliminarily, how we thought that initial showing for the state might go. But again, we have obviously the actual hearing testimony. We have the record. We've got the video, which I'm going to pull out Ian Carroll's new research platform today. Very, very cool. But again, let me state this again, just the legal standard for everybody. And why is it doing that? This makes no sense. No wonder. Okay. So state again. So the state will first, and then again, what we're talking about is authenticating or getting text message evidence into a criminal case in the state of Utah under the rules of evidence. The state will first need to present enough evidence to the judge to convince, in this case, him that a reasonable juror could find the text to be authentic. And then assuming the judge, again, in this case, Judge Graff, finds that the state has made that initial showing that a reasonable juror, impaneled on the future hypothetical juror, could decide, could find that the text messages are indeed authentic. Then it will be up to the juror, obviously, when the case goes to the jury, to apply that evidence to the overall facts in the law, basically applying the text message evidence in the context of the capital and other offenses to which for which Tyler Robinson has been charged currently. The rules of evidence don't, and I know I've stated this, rules of evidence don't necessarily apply at a preliminary hearing, okay? And as we saw many, many times, the 1102 Article 1, Section 12 of the Utah Constitution allow, reliable hearsay at preliminary hearings, in the evidentiary record in preliminary hearings, again, which we saw a ton of that. I mean, the state primarily relied on what they called 1102 evidence in establishing, the probable cause to charge Tyler in this case. And again, we will discuss that in, a bit more in depth here in regards to the text messages. In this case, and as we will discuss further in a bit, the FBI agent who actually took the photos of the text messages offered into evidence, again, allegedly between Lance Twiggs and Tyler Robinson, did not testify. And so the text messages in this instance were accepted into evidence partially based upon hearsay, right? The testimony of Agent Davis, which again, might not be admissible at a trial, right? And so obviously there were shortcomings as presented at this preliminary hearing, potential shortcomings, right? But again, if they go to trial, I'm venture to say that they're going to need to get that FBI agent, I think Larson was his name, or whoever that is, to come and testify about actually taking the photographs of the text messages that were admitted into evidence. So again, as such, the judge admitting the text messages here at this preliminary hearing does not necessarily mean that they will automatically be admitted at a trial. If the state can't provide all the foundational evidence free from inadmissible hearsay and or other evidentiary deficiencies. And again, we'll talk about this a little bit tonight or in further tonight. Fortunately, if this is a real court case, right? If it is a real court case, and it very well might not be, right? Just my opinion, allegedly. We should see the defense. We should have seen the defense cross-examine Agent Davis or call him on direct at this preliminary hearing. We did not. So I'm going to put I put in my outline here in all caps, should see the defense file a pretrial motion in limine. As I've stated before, a motion in limine is a pretrial motion asking the judge to do a preliminary ruling on a piece or pieces of evidence that one side believes the other side is going to try to introduce. Okay. And as I've stated before, if judge rules on, or when judge rules on a motion in limine, doesn't mean that that's sufficient for appeal purposes, meaning that if judge rules a piece of evidence inadmissible at an upcoming trial, the party attempting to offer or proffer that evidence into the record still needs to make that offer or proffer at trial and get denied in order to preserve their appeal. So just making everyone aware of that. Not that that's 100% relevant tonight, but just so y'all have a little bit more general legal knowledge on these matters. But anyways, we should see the defense file a pretrial motion in limine seeking to exclude the text messages, them ruled inadmissible for a lack of sufficient evidence, showing a reasonable juror could find them authentic. And as we know here, there is, as we know, and we've obviously spoken at this, tons of other content creators have spoken about this at length, but there is, in my opinion, quite a bit of evidence that tends to cut against the authenticity or a finding of authenticity of these text messages, including but not limited to, in my opinion, the actual content of the messages. Okay. And we'll talk about that a little bit tonight as well. But is that evidence sufficient to convince judge that a reasonable juror wouldn't find them to be authentic? And again, as I stated, it's really a two-part step here. First, it's judge assessing whether he believes, in this case, he believes a reasonable juror could find, these text messages to be authentic. And if he does, then he'll let them in. And then it would be up to the jury to ultimately assess whether they are actually authentic based upon, both the substance of the messages themselves and presumably the circumstances around their formation, their publication, their acquisition by law enforcement, et cetera, et cetera. So again, just because the judge allows these text messages in, as he did here at the preliminary hearing, one, doesn't mean that he's going to let them in at the trial, and two, doesn't mean that the jury has to find them to be authentic. Okay. Just wanted to throw that out there. But again, so whether a reasonable juror, one, whether judge is going to let these in at trial, and two, whether a reasonable juror, if they are let in, is going to find them to be authentic, obviously remains to be seen. Take away the hearsay testimony of Brian Davis, meaning that take away Brian Davis's testimony that, Agent Larson, he spoke to Agent Larson, who told him about, taking the photos of these messages. If that's ruled inadmissible hearsay, and they don't have Agent Larson come testify at trial, there might not be enough predicate evidence to convince judge to allow those messages in. Okay, so again, a lot remains to be seen. Tonight we will review the 2024 Utah Sandoval case. Again, this is a case that, give me just one second. I got Shadow here. It's time for her dinner. Go get your food, baby. We're going to review the 2024 Sandoval case. Obviously, it's a criminal appellate case in Utah, which is, to my knowledge, like the most recent iteration of the standard, the evidentiary standard in Utah. Again, governing the standard and process required for text message authentication. Sorry about that. And then we will review this case in light of the authentication evidence adduced by the state at the preliminary hearing this past week. Again, as I've stated, I would like to note, I'm going to have to note on every single live stream and video I do from here on out about this case that the defense utterly failed to cross-examine Agent Davis and also failed or refused to call him on the stand for direct examination. No examination of Agent Davis. Again, I find that heinous. I just cannot understand, or I don't have a good reason or explanation for that. This case trial very well could be, again, in my opinion, allegedly, one very large and deep psychological operation, allegedly, in my opinion. Okay, one thing I wanted to, and I said this before, but I just want to reiterate, I went and paid for a membership to Ian Carroll's web research application. Okay. And that application, they have uploaded basically uploaded the entire preliminary hearing, both video and then the transcript. And I think all the documents they could get a hold of from there. It's incredible, right? So it's incredible. I'm going to share it with you tonight, what I pulled up in regards to these text messages, because it's just incredible. Like literally it tells you, it's kind of like a chat GPT, but it's talking about this case. And then in regards to this hearing, when it makes a point, it has a footnote, and you can click the footnote and it will take you to the video of the preliminary hearing where that was stated or introduced, et cetera, et cetera. So really incredible. I can't wait to whip it out. And I have a feeling that this is going to be a tool that I'm most definitely going to be using a lot moving forward in the future. So I can't wait to share that with y'all. But first, though, we're going to take a look at the Sandoval case. Before I do, I'm going to check the chat for just a second. If you haven't already, please like, comment, subscribe. This is the Entheogenic Esquire YouTube channel and podcast. I'm Attorney Greg Lake. If you haven't been here before, we are very honored and grateful to have you. I will say that I have one of the best groups of subscribers on YouTube, without question. We keep a high IQ and high energy chat here on these live streams of mine. I mean, at least I feel so. So again, if you haven't already, please feel free, if you have the bandwidth, to subscribe. We'd love to have you. And hey, if you feel called, grab you a membership. I try to do at least one members only video or live stream, I say, once a week. And so what I like to do at those is, one, get to know my members a bit better, but two, talk about potential future content and really just get the pulse of the community on a lot of these issues in the Tyler Robinson case. So if you want to be a part of that crew, please join and get a membership. We'd love to have you. Let me check the chat real quick, give shout outs, and then we will proceed on to talk about the Sandoval case. Let's see who we got. Debbie, good to see you, love. Glad to have you. Daisy, good to see you. Thank you for showing up. Love to have you. Jax is doing good. Shadow's doing good. We're cooking them dinner right now. Raining, good to see you. Thank you very much for the super chat, Debbie. God bless. I love all of y'all. Susan, very good to have you. As always, God bless you. Thank you for being here. And let's see. See, basic is basic niche here. There's basic. Hey, bless those computer nerds for putting web together. Web is an incredible look. And again, don't let me lie to you. I haven't done, tonight was the first night. My brother-in-law and I were watching a Ian Carroll episode, and he whipped it out, started talking about it. I had a few spare dollars to go ahead and throw down on it. So I did, but I think y'all are going to be very amazed at what they've been able to do with this platform. Inga Turns loves my shirt. Thank you very much. Yeah, so I am an attorney. I specialize in psychedelics, more specifically psychedelic-based religion is my specialty. So mushrooms I have a very fond relationship with the mushrooms, and so this shirt for me is very expressive. So thank you for commenting, and I love each and every one of you. Getting more comments on the shirt. Thank y'all. Let's see. Nosy Google. Here you go. Nosy Google. Good to see you too as well. God bless. Thank you for showing up tonight. I know we've been chatting in the comments, and we were chatting on Adam's live stream yesterday. Good to see you. Listening while cooking. The best Heather. Thank you very much for being here with us in any capacity. Thank you very much. God bless. Let's see. Here goes basic niche. I'm curious on how much or how little Tyler and Twiggs supposedly communicate on the 10th. Yeah, we're going to talk about that. Because, I went, obviously in preparation for this, I went back and, I viewed all of Brian Davis's testimony. Obviously, the video of Lance Twiggs was part and parcel of Brian's testimony, right? Because he had to essentially prove up that video, right? He was there whenever that 1102 statement was taken. And so he was there to prove that up, say it's, authentic, of the actual interview that occurred, et cetera, et cetera. So that's part of Brian Davis's. And and we'll get into the intricacies here in a bit when we check it out. But yeah, it's very unclear what the extent of communication that they had on the 10th. I do remember off the top of my head right now, that, it was stated that the first direct message, text message or communication that he had with Lance was this 11 p.m. automated message. And I think reading Chris Frill's work, it's my understanding that that message was the one, right? The first one that said, hey, look under the keyboard. Like, you know, you'll find a surprise there, some of that nature. We'll go and look at it more specifically tonight. But yeah, but then after that, it seems like he says something, I can't remember off the top of my head, that tends to contradict that. Okay. So anyways, we'll get into that. And then, you know, obviously, and I guess maybe some of the confusion too is because if his first text message allegedly came at 11, obviously the 11th, right? The 11th would have clicked over at midnight. And so that might be why there's some confusion on exactly what happened on 10th versus 11th, but we'll get into that in just a bit. Let's make sure. So get towards let's see here. My dog. There was nothing in the probable cause hearing attaching Tyler to the crime alleged. So, yeah, I mean, to that extent, other than you could say the text messages, I guess, and then his alleged confession to Tyler. But, you know, obviously the state is of the opinion that the video is of Tyler Robinson at UVU on the day of the incident, and that's him taking the alleged shot from the roof, et cetera, et cetera. But I don't think, to me, that doesn't, to me, that doesn't prove that was Tyler. Okay. That does, to me, it looks nothing like Tyler. And then the other videos are not clear enough to convince me that it's Tyler. So then you kind of revert back to the text messages, and then also the DNA evidence, right? The DNA, the ballistics evidence, nothing is 100% solid tying Tyler to crime. I tend to agree. Obviously, there's differing opinions on this, the state, Fed sloppers, but I tend to agree. I don't think that there was anything really solid enough. I'll put it to you like this. I don't think there was anything solid enough, in my opinion, to send this to trial on. I think judge will have a differing opinion, or judge will feel pressure to have a differing opinion, right? I did like Barron's discussion the other night of the fact that, like, Don Jr. and Fox News, just basically there's a lot of pressure on the judge, right? Particularly in conservative political circles, to find probable cause to what they call bind Tyler over for trial, meaning that there's probable cause, we're going to trial, right? But they call it binding over in Utah, just FYI. Let's see. Hey, Regina, good to see you yesterday as well. So anyways, there we go. All right, so let's go ahead and pull up the Sandoval case real quick. I will share screen here with y'all. Let's see here. Okay. So this is the Sandoval case. We're not going to read this whole case, y'all. I made an outline over here of the relevant portions for us. And so I'm going to go through this outline, and then we will look at the relevant portions. Now, Sandoval, this case demonstrates that authentication under Rule 901 of the Utah Rules of Evidence presents a relatively low hurdle, okay, for the state to introduce text messages, you know, to the jury, to the record. But it does still require that the state build a coherent evidentiary chain. The question in Tyler Robinson's preliminary hearing is not whether some authentication evidence existed. It obviously did, but it's whether the state adequately connected each link in the chain, from the original photographs to the identity of the phone to the accuracy and completeness of the exhibit, okay, which I think was 16.1. So again, we're not saying here that these are authentic text messages, just whether the state had sufficient evidence to show for judge to believe that a reasonable juror could find them to be authentic. Again, it's a low hurdle, just like the probable cause hearing was a low overall evidentiary hurdle. So is getting the judge to find, text messages sufficiently authentic to put it in front of a jury. And whether the witness providing the foundation had sufficient firsthand knowledge. So again, like I told y'all, 1102. God, Woo. Yeah, 1102 evidence, right? So it's Utah Rule of Evidence 1102 allows for this reliable hearsay evidence. And so because of that, Agent Davis was able to testify that this Agent Larson from the FBI, told him about taking the pictures of the text messages from Lance's phone. And then obviously too, Lance Twiggs in his recorded statement also worked to verify that those messages in those were pictures of messages on his phone. Okay. So in all fairness, those two things kind of work together. But again, at trial, there's going to have to be another analysis. And like I said, hopefully the defense will actually file what's called a motion in limine. And, I think if the defense is going to get those text messages ruled inadmissible, they're really going to have to not necessarily attack whether the state collected this evidence sufficiently, but whether there are sufficient circumstances surrounding the text messages themselves, both in the substantive content of them and how they were allegedly sent. And let's be on, and let me say this too, is that also might just be something reserved for the jury, right? Meaning that you could bring up some of these things like, the substance of these doesn't seem like these two sent them. Trying to think of some, like the timeline of these messages as they're kind of written doesn't make sense with other events going on in and around. Just by way of example, I think there's a part in there where Tyler talks about these, other suspects that have been apprehended or taken into custody. And there's been allegations that there's probably no way he should or would have known that. But again, that might go to weight and not sufficiency to come in. And so again, that would be judge's call ultimately, but it definitely is something that the defense is going to want to bring up, preferably in a motion in limine pre-trial. Okay. Let's check the chat real quick. Don Jr. is now putting statements out. Yeah. I want to say that Barron said that I don't really follow Don Jr. on X or none of that stuff. Just my personal opinion is Don Jr. doesn't seem like a person of very good moral character. Just my opinion, assessment of him, right? God bless him. He's just not somebody that I look to follow or, care anything about his opinion. But yeah, Barron did mention that he's putting out statements of how guilty Tyler is and things of that nature. I mean, I think we can all kind of read through that. Let's see. Here goes a comment. It's just zero. Good to see you. There is a 20-minute plus gap from the stairwell to the roof potato cam of Pixel Man or the roof. If the last good view, which is arguable, of Tyler Robinson does not track him to the roof, I object. Laughing out loud. Yeah, and you absolutely should, right? You absolutely should. That's a good point. And yeah, I guess while we're here, y'all, if y'all could please show some support for the video, be very much appreciated. I'm about to get into some pretty deep. I'm trying not to get part of my job, my regular job. I specialize in freedom of religion cases under the First Amendment, the Federal Religious Freedom and Restoration Act, which is a relatively little practiced, very not well known area of law. And I do a lot of education. So I do pride myself on being able to take rather dense and somewhat complex legal concepts, particularly in the rule of evidence, and boil them down to make it digestible and understandable for people. I hope I've been doing a decent job of that over the course of this case. I think my longtime subscribers would testify to that. So yeah, if you could take the time, if you haven't subscribed, like this video, support, be very much appreciated. I love y'all. And then Tammy Lynn here says a lot of the evidence was tampered with. I think there's tons, obviously we know that the crime scene was paved over. We do know that the SD cards were ripped out. We saw on video tons of people just generally messing with the crime scene in and around, people stealing hats from the table, et cetera, et cetera. Yes, we do know that the evidence has been tampered with. See, same. All I do is feel like I consume content in this case. Me too, right? Me too. I do the same. One, because I'm just so deeply interested and think this is a very important case to follow, but also to be able to bring y'all stuff on these live streams. The only fact in evidence is that Charlie Kirk said, well, my dog, I mean, sure, you could definitely say that. I mean, at least in theory, it is. I think a lot of people would, go toe. I mean, and we're not like we're debating toe to toe on that fact, but I think some people have an idea that he might still be alive. I've tried not to express a hard opinion one way or the other on that. I will say that as of lately, I'm kind of gearing towards maybe he's still with us. But again, I'm reserving any, hardcore judgment on that. Susan, yes. Hey, Lindsey Graham, look, and I hate to, not that I'm celebrating the death of anybody, any human being, don't get me wrong, but I do feel that Lindsey not being with us anymore might be a pretty good thing for America. And I'll just leave it at that. But God bless his family. God bless him. I hate losing loved ones. I lost my mom at an early age. So I do, feel for them. But yeah, I think that our country is going to be just fine without Lindsey Graham there. So anyways, let's go ahead and hop into the Sandoval case here. Start my outline. So anyway, Sandoval, this is a case where the defendant was convicted of forcible sexual abuse. On appeal, the defendant Sandoval argued ineffective assistance of counsel because his attorney stipulated to the omission of text messages that allegedly were not properly authenticated. Okay. And so here, obviously, we didn't have a stipulation. The defense didn't stipulate to the admission of the text messages. But to be quite honest, with them not cross-examining Agent Davis, who was primarily used to authenticate those text messages, they might as well have, right? And in all fairness to them, they did want to cross-examine Lance Twiggs and refuse that opportunity by the judge for, a multitude of reasons, and they didn't get to do that. But again, to me, they might as well stipulate to it still with Agent Davis, right? Because I think the primary vehicle used by the state here was Agent Davis to authenticate these text messages. Parts of Lance Twiggs' testimony certainly provided, it bolstered elements of Agent Davis's testimony going to the authentication. But ultimately, it was Agent Davis. They should have cross-examined him. Okay. Let me read a little bit from the Sandoval case about the relevant parts that we're worried about. And again, just to back up for a second, Sandoval, this is a criminal case from Utah Court of Appeals, basically governing. And I think what y'all will see too is that a lot of the facts discussed in this case about, how the state properly authenticated these text messages, you'll see some factual consistency here, with what has happened in the testimony in Tyler Robinson's case, almost like, that it was patterned the same way. And I'll just leave it at that. Almost like these things were patterned, like the authentication, the state here in Tyler Robinson was almost patterned in some way after the factual flow of Sandoval, as we're about to see. So here says the text messages. So Sandoval contends counsel's stipulation, talking about Sandoval, who's the criminal defendant, his counsel's stipulation to the admission of the text messages constitutes ineffective assistance of counsel because the text messages were unauthenticated. Now, that's his contention. The court says here, we disagree. Specifically, Sandoval cannot show it was deficient performance for counsel to stipulate to the admission of the text messages. The text would have been admissible even if counsel had not stipulated to admit them. Okay, so again, Sandoval, the defendant, alleging that he had ineffective assistance of counsel because they stipulated to the admission of text messages, which he stated, were not properly authenticated. The court said, and again, this on appeal, the court said no. Even had your counsel challenged the authentication or the authenticity of those messages, they would have been found, at least on the front end, properly authenticated. The court then goes into the standard here, right? And it says to satisfy the requirement of authenticating or identifying an item of evidence, the proponent must produce evidence sufficient to support a finding that the item is what the proponent claims it is. Okay, and this is just general rule, Utah Rule of Evidence 901. When we're talking about items of evidence, whether it be text messages, whether it be a DNA swab, something to that effect, you have to show that this is authentic. That, for instance, if we were talking about a DNA swab for Tyler Robinson, this is the DNA swab that came from Tyler Robinson, right? But you got to show this is authentic. Thus, a party seeking to introduce writings or other documentary evidence, right? So we're really specifically looking at documents here, must authenticate the evidence before it can be admitted. However, proper authentication does not require conclusive proof. Instead, the proponent has to make only a prima facie showing of authenticity. Going back to what I said, ultimately, the jury will determine whether an item of evidence is authentic, in this case, text messages, but it will first be on the judge to based upon a showing of the state of a prima facie showing of authenticity. Okay, so meaning that the judge themselves don't have to believe that they are indeed authentic, just that there's enough evidence that if the jury were to hear it, that they could reasonably conclude that they are authentic. Okay, and so in this instance, Judge Graff could harbor himself some reservations about the ultimate authenticity of the text messages, but still let them in because there is some sufficient evidence, some evidence that is sufficient for a juror, a reasonable juror, to find that they are indeed authentic. Again, judge might disagree with that, but could still be bound to let them in. And I go on. Although Utah's courts have had relatively few opportunities to consider the foundational requirements that must be met for text messages to be admitted. And I hope y'all are seeing this. Man, do I have this up? Okay, cool. Yeah. To be admitted. When they have joined a number of other jurisdictions that allow text messages to be authenticated by circumstantial evidence. For example, in the State versus Authenticated case, we held the state met its burden to make a prima facie showing of authenticity by presenting evidence that the phone, and so pay attention here, right? Because they're going to be talking about other cases and what circumstantial evidence was sufficient in those cases in order for the court to rule that, upfront authenticity, right? And so the reason why we pay attention here is because we're going to then apply these circumstantial facts from other cases to hear what we saw in the preliminary hearing and assess from there. But anyways, by presenting evidence that the phone from which the text messages originated belonged to the defendant and that he had possession of it at the time the messages were sent. So here, now one thing, and maybe I should or shouldn't go into that right now. I'll say this preliminarily. I don't think they presented evidence, or at least any sufficient evidence, to pin that Tyler had possession of his phone at the time these messages were sent. So I just wanted to quickly point that out, but we'll go deeper into this in a bit. Specifically, the evidence showed that the texting questions were sent from the phone number assigned to a phone found in the defendant's apartment. So basically, the defendant had the phone, where the message came from, in their apartment. That the phone matched a witness's description of the phone he saw the defendant using during the crime, right? So that's it. So there was a witness in this Authenticated case. A witness testified that, during the commission of the crime, that phone that y'all found in defendant's apartment, of which phone number these messages came from, that was the one used during the crime. So basically connecting all the way to even the defendant. There'd be testimony that the defendant had that phone texting during the commission of the crime. Okay. And that the crime occurred during the same time frame when the text messages were sent. Okay. That's probably I would say in terms of having the most solid bit of proof that these are authentic text messages, that's probably as good as it'll ever get when you actually have a witness being able to testify to seeing the defendant using the phone at the time the messages were sent. Okay. Next, they talk about the State v. Welsh case, right? There it says, we held that the state's several pieces of evidence, such as the timing and content of the messages, when combined, were sufficient to support a finding that defendant authored the text. The timing of the messages, for instance, supported a finding that the defendant had sent them because they were sent just a few hours after the defendant broke into the victim's apartment and tried to tie her up. And the content of the messages, including information that was particular to their relationship and to things that happened that evening involving the defendant. So again, here they're also talking about the content of the messages, right? The content of the messages indicated certain facts and other circumstances that only the defendant would have known. Again, kind of further identifying that those messages came from that particular person, the defendant. Okay. So it goes, thus we concluded that these corroborative circumstances support a finding that the defendant had sent the text. Okay. So again, y'all can probably see where this is going in this case. And I'm sure many of y'all's brain is already starting to kind of like, jog of what the evidence or testimony was in the preliminary hearing and what this legal standard requires in terms of, getting text messages into evidence. Now here the court kind of goes to the application of that standard to the facts in here, the Sandoval case. They say, here the timing of the messages is less clear than in Welsh, particularly since the photograph texts do not include any dates. Okay, so we're gonna get into some stuff here. But they do include the days of the week and times that, together with Detective 1's testimony that he correlated the days of the week with the dates and determined the messages were sent between March 10th and March 15th, make it possible to piece together the timing. Okay, so I think y'all might see potentially some analog here in this case with some stuff that we've seen in this case. Okay. The messages also contain details about the parties' relationship, where and with whom they live, for example, and about the events of the night in question that only they, Sandoval, Robin, mother, and friend would have known. Moreover, Detective 1 testified that he photographed the text in Sandoval's contact page on mother's phone. Let's see, list and testimony. Anyways, and Detective 1 testified that he verified that the text to mother came from Sandoval's phone number by locating a county document on which, and we saw some of this, right? We saw some of this, or we heard some of this from Davis, checking this phone number with county records. We'll talk about that more in a minute, but he said, Detective testified that he verified the text to the mother that they came from Sandoval's phone by locating a county document on which Sandoval had put the same number down as his personal contact number. In light of these corroborative circumstances that supported a finding that Sandoval had sent the text. Let's see. Reasonable counsel could have chosen not to challenge her authenticity. So again, Sandoval challenged his counsel stipulating to their being admitted, but the court here is just saying, now that we've run the actual analysis that would have been run at the time, we conclude that they didn't commit, that they didn't provide you substandard service, legal counsel, by stipulating to the text just coming in. Okay. It was not deficient performance for trial counsel to make an objection that would have been a futile exercise. Therefore, Sandoval has not overcome the presumption that counsel's decision to stipulate might be considered sound trial strategy. In sum, the text messages would have been admitted into evidence even if counsel had not stipulated to their omission and instead raised an objection to their lack of authentication. Okay. Let's see. Accordingly, we conclude counsel did not perform deficiently, and that this claim of ineffective assistance of counsel fails. Okay. Anyway, so like I said, this is Rule 901, Utah Rule of Evidence 901. To authenticate evidence, the proponent must produce evidence sufficient to support a finding that it is authentic, that it is what you're claiming it is. In this instance, state producing these text messages must make a sufficient showing that, in fact, those text messages are messages between Lance Twiggs and Tyler Robinson on the alleged dates at the alleged times, with the subject matter as stated. So authentication is not conclusive proof, right? It's just that upfront showing that a reasonable juror could find these to be authentic. It's only a prima facie showing, and circumstantial evidence is sufficient. Okay. So again, let's review real quick what the state did, or what the state showed happened in the Sandoval case to authenticate the text messages up front. So the defect, and we're going to do a side-by-side comparison with what happened in this case. But anyways, detective testified that he viewed the messages directly on the mother's phone, that he photographed them, and that he photographed Sandoval's contact page, meaning Sandoval's phone number on the, and again, we'll talk about it in a minute, but so, obviously when you have a contact in your phone, you go to the contact page, it'll say, who that person is, what their number is, or at least it'll have whatever name you entered for them in your contacts on your phone. Let's see real quick. So here in paragraph 9 in the Sandoval case, it talks about, exactly what happened there. It says Detective 1 photographed the text and Sandoval's contact page on mother's phone. He then verified Sandoval's phone number with a county document in which Sandoval had put that same number down as his personal contact number. So the defendant had filed some document with the county, I don't know, maybe some type of deed or some type of other application of sort with the county, where he had put the number that was listed in mother's phone under his contact name. Those two things matched. It goes on to say Detective 1 also confirmed the messages were sent between March 10th and March 15th and explained that he had correlated the days of the week on the photographed text with the dates to make that determination. And thank you, Rick, for starting this conversation with me via email. But I believe on iPhones, whenever you have a text stream going, so for instance, if Rick and I were texting this past week, right, and, you look at the messages, like right now on Sunday, if I were to look at the messages, let's say from Wednesday, it would just say Wednesday at whatever time. Now, once the messages become a week old, that's when it starts to list the day, the date, and the time, right? So the messages, and just at least this is the way I take it on my iPhone, the system I saw just the other day when I was emailing with Rick, was that, once they become a week old, then that's when they put the date, time, and so like Wednesday, June 15th at 6:50 p.m. Whereas, right now it would just say Wednesday at 6:50 p.m. Rick sent this message, or I sent that message. I hope that makes sense for everybody. The detective photographed the contact information. So the detective did not simply photograph messages. He also photographed the contact page, showing who the conversation purportedly was with. So here, I don't know if they introduced an actual photograph of the contact page, but I do believe, if my memory serves me correctly from today, that Lance Twiggs did testify that the person listed as the contact is indeed Tyler Robinson, which is connected with, the phone number that they didn't publicly disclose. 3, the detective independently verified the phone number. Okay. And I think we have a bit of that here, or at least allegedly have some of that here. But the defendant checked a county document, like I just said, where the defendant Sandoval himself had listed the identical phone number as his own personal contact number. Okay. He's out there self-snitching. Just kidding. Okay, next, the defendant verified the detective verified the timing. Again, I think we're going to see some of this in this case as well, although I think by somewhat different means, but we'll talk about that in a second. The photographs did not display calendar dates. Okay. Again, if those photos were taken the same week, at least in an iPhone, then it's not going to have the actual calendar date, but would say the day of that week in which they were sent and the time. But instead, the detective testified to correlation. a correlation of the days of the week and the timestamps, okay, to determine that they occurred between, in that case, March 10th and March 15th, okay? And then lastly, the internal content of the messages corroborated authenticity. Right? The court in Sandoval emphasized that the conversation itself contained information known only to the participants. And again, I think, we have some of that. Again, these are alleged texts. Please don't take me as saying that I think these things are authentic. I think that there is information within the substantive information in those text messages, which theoretically you could say only Tyler Robinson, Lance Twiggs would particularly know. But anyways, in the Sandoval case, it had, where everyone lived, who lived there, details surrounding the actual assault in that case. And then again, these are facts that only Sandoval, the defendant, the mother, Robin, and friend would know. Okay. And then detective testified the messages were what they purported to be. Again, the rule allows authentication through witness testimony. The detective in the Sandoval case testified that he photographed the messages. Got a little problem with that here from the preliminary hearing. We'll get into it in a second. And that they were what he claimed they were, right? Again, that's conclusory type testimony, but, it is what it is. Now, obviously, if the person, Agent Davis, didn't personally take those photographs, wouldn't be able to, his testimony that they are what he claimed they were wouldn't be given as much weight as if it was actually the FBI agent Larson up there testifying to that, because that agent was allegedly there to actually take the pictures. Why the court in Sandoval found authentication sufficient. The court combines all of the above, and the important sentence from the opinion down here in paragraph 25. Let's see, is these corroborative circumstances supported a finding that Sandoval had sent the text. And notice that the court never relies on one single fact, right? In 25 here, it goes through all these different facts that were material, relevant to the analysis, including but not limited to, phone ownership, verified phone number, timing, content of the messages, photographs of the text messages, detective testimony, and then corroborating circumstances. Okay. Anyways, so the court again concludes that even if the defense counsel had objected to the admission of those text messages, there was sufficient evidence to find them authentic on the front end and would have allowed them in for the jury to make the ultimate call of whether they are indeed authentic. All right. So I'm going to now, let's go ahead and look at some of the video and stuff from the Tyler Robinson case related to the workup of these text messages, right? I'm going to play we will play, let me just do this. Let me just pull up Ian's, I was going to play a video, the actual long form of the hearing, but I know that y'all have probably seen that tons of times. So let me just pull up real quick Ian's platform so that way I can show it off to y'all. I feel so sophisticated having found this thing for real. This thing is awesome. And then, and I think that it actually does go through all this. I'll try to take note, and if we miss anything, we'll go back. I'll go pull it up on the main video. But look, I swear, I think that Ian's platform got it all right. Let's see. And I'll take notes here as we do it, just to make sure we hit all the high points. But let me go through some of the chat real quick. Let's see. Yeah, if y'all don't mind, please like, comment, subscribe. Just any support you can give would be very much appreciated. I am attorney Greg Lake. Welcome to the Entheogenic Esquire YouTube channel and podcast. For those who are just coming in, God bless you. We're about to get into a substantive analysis on the legal authentication of these text messages. I don't know if you've seen an analysis this deep or this pointed, right? And again, that's not coming from ego, but I'm trying to provide, as other content creators I'm sure do, analysis that you don't get anywhere else. And so, if you have the bandwidth, if you have the drive, please give us some support. I'll be very much appreciated. But yeah, let's just go ahead and jump into this with Ian's platform here. All right. Bam. Here we go, y'all. So, yeah, I'm not going to go through and do a demonstration of all the bells and whistles per se. But let's see. Where am I at? So, here's what I typed into the query bar here. And that's the only thing I don't really like about it. Man, it just has kind of a short screen. Let me see if I can do full screen on this. There we go. Maybe that'll help. Oh, that's a lot better. Yay. Okay, cool. Oh, cool. So here's what I typed in, y'all, into this this platform. I put, I'm looking for all of the preliminary hearing testimony concerning the alleged text messages between Tyler Robinson and Lance Twiggs. Hey, Abs, Fifi, good to see you. Thanks for rolling in. Regina, Robert Wells, good to see you, brother. Good to see you. See anybody else? Rick, I don't know if I gave you a shout out earlier. Good to see you, brother. God bless. Thanks for the email exchange. I'll check those emails again in the morning and get back to you if you sent me one. I haven't responded. See what my dog says. There was never a comparison of two separate phones communicating with each other. There's only a picture of a phone screen that does not identify the phone taking the picture. I think I know what you're getting at there. So the way I take it is that, yeah, it was I don't know if it was a picture taken from a phone. Like, I don't know if it was Agent Larson's phone taking the picture, but I would hope it was an actual camera. I hope that they have enough investigative tools to have an actual camera out there to take a picture. But hold on, here goes another comment from you. Where is the physical texting evidence actually contained on the sending and receiving phones? Well, they produced obviously pictures of one end of it from Lance Twiggs' phone, but they did, again, and we'll talk about this, and that's a very good point. Something I would definitely point out on the defense is that, they also got Tyler Robinson's phone. They also got a search warrant for Tyler Robinson's phone. My question just from the first is that, especially if Lance Twiggs' phone had a crack in the screen, why didn't they take Tyler's phone and, take the pictures from it? You know what I mean? Because, I would presume it doesn't have a crack in the screen. It's actually the defendant's phone, right? So it seems better to hold it against somebody for being on their actual phone. That's at least a little bit better. I think that's what you're kind of getting at there, my dog. So let me know. But yeah, I think I know where you're going with that, and I tend to agree. But again, we'll point out some more stuff too. But anyways, let's go ahead and jump over here. So I'm looking for all of the preliminary hearing testimony concerning the alleged text messages between Tyler Robinson and Lance Twiggs. It reads, Web. I'll start by searching broadly across the collection to find the preliminary hearing testimony and any mention of text messages between Tyler Robinson and Lance Twiggs. It says 6 steps completed. The text messages between Tyler Robinson and Lance Twiggs' preliminary hearing testimony. The preliminary hearing testimony concerning these messages is extensive and comes primarily from day 4 of the hearing through the testimony. It got this wrong. FBI Agent Davis. It's actually SBI Agent Davis. It was the State Bureau of Investigation. So just, quick correction there. With some additional context from witness Mr. McBride and from the court's ruling on. Hey, this is funny, y'all. This is hilarious. You know, if y'all remember correctly, the before they let Lance Twiggs video roll, obviously they did like, man, an hour or more of objections back and forth about the 1102 statement from Lance Twiggs. And if y'all remember, the defense was basically saying that this is more or less just McBride testifying, essentially. That essentially it's just Mr. McBride testifying for Lance Twiggs. You know, it goes beyond leading. He's actually like doing the testimony for him, and then just having Lance Twiggs in many places just simply agree, like, oh, yeah, that. To the extent that he did this, to the point to where now this AI platform is saying that it was Mr. McBride's testimony, right? So anyways, I think that's funny. I'm actually going to take a screenshot of that real quick, y'all, because I think that's absolutely hilarious. Hold on. I might make an X post about this tomorrow, because that, to me, that's hilarious. The AI actually thought it was Mr. McBride's testimony. I guess they thought Lance Twiggs was actually doing the questioning. So here we go. Chain of custody and authentication. The testimony establishes a detailed chain of custody. On September 12, 2025, the morning after the shooting, Lance Twiggs voluntarily came in for his first interview with the FBI. Again, now for sure the FBI was there, but I think they were actually technically, it was with the State Bureau of Investigation, Utah, but that's nothing we need to go into detail about. During that interview, Twiggs physically showed the agents his phone with the text messages visible and allowed Agent Larson with the FBI to photograph the scene. Those photographs became State's Exhibit 16.1, an 18-page collection of photos of text messages between Tyler Robinson and Lance Twiggs. Let's see. Key authentication facts elicited from Agent Davis. Okay, so let's start taking note of these. Because we're going to do a side-by-side comparison with what was offered in Sandoval. So here it says, Twiggs identified the phone as his own, noting a large crack in the upper left screen as a distinguishing feature in his second interview on April 4th, 2026. Okay. Now, this is what is the coolest thing with this platform. Like when I saw this right here, y'all, I automatically went and signed up for this platform. Y'all ready? Well, it should be playing a video here. Oh, here we go. Okay. Come on. All right. Let me see. Let me try this again. Man. Not sure why this isn't loading. Surely did earlier. Let me do this. I'm not sure why it's not playing these. Man, this upsets me. Earlier it was playing. Let me do this. Let me try to back out of this. Well, this has the timestamp, so I'll tell you what I'll do, y'all, is oh, there we go. Come on. Oh my God. Okay. Let me I hate that it did like this. Try it one more time. Okay. Well, here's what I'll do. I will just pull up the video. And it does give the timestamp, so I can just play it on the regular video over here. So I got this. Okay. So yeah, here's what I'll do. I'll go to hold on, it's playing over here. Let me try it. Let me try it one more time.
Shown to him during his second interview.
Yeah, maybe it does something with trying to do it. Sharing screen might have something with, maybe it doesn't do it very well. That's all right. I got it pulled up over here. Remove. Okay. All right. So let's go to the first one here. All right. So back to where we were. Twiggs physically showed the agents his phone and photographed. Those photographs saying 61. Key authentication. Twiggs identified the phone as his own, noting a large crack in the upper left screen as a distinguishing feature in his second interview on April 4th, 2026. Okay, 134. Here. Okay, God, hold on. That's the wrong one. That's my bad here, y'all. I got the wrong video. My bad. Okay. All right. So again, so this right here is going to be Twiggs identifying his phone, or at least testimony that he identifies his phone as the one with the large crack in the upper left screen as a distinguishing feature. So here we go. Make sure we got it.
Personal phone with him at the time of the September 12th interview?
Yes, he did.
And was this same text thread that we're seeing in State's Exhibit 16.1 shown to him during his second interview sorry, let me get the date right, April 20th, 2026 at the Utah County Attorney's Office that we just observed part of in State's Exhibit 16?
Yes, it was shown to him.
Was he asked how Tyler Robinson is saved in his phone, like as a contact?
Yeah, just as Tyler.
Without saying it, obviously, did he identify Tyler Robinson's phone number?
Yes, he did.
Did you check the number that Mr. Twiggs gave as Tyler Robinson?
Okay. Sorry, I wasn't even sharing that, y'all. My apologies. We'll do it one more. We'll play the whole thing real quick because I have the timestamps here. Turn it down just a little bit.
Twiggs, was he shown or referenced certain items of evidence?
Yes, he was.
What types of items of evidence was he shown?
It was the text messages between himself and Tyler Robinson, a Discord chat messages, and a handwritten note.
And then we also saw in the video, he was also shown the FBI press release photos of the potential suspect.
That's correct, yes.
Have you reviewed all of those items as part of the investigation?
Yes, I have.
You're familiar with them?
Yes.
All right, I want to put just on the witness's screen what's been marked for identification as State's Exhibit 16.1. And for the record, this includes the edit that the one edit that the court has previously ordered.
Thank you.
Let me know when you see that on your screen.
I see it. I see it now.
Do you recognize this?
Yes, I do.
What is it?
This is a photograph of screenshots of text messages between Tyler Robinson and Lance Twiggs. This is a photograph of Lance's phone.
So sorry, you said photograph. You also said screenshot. Can you differentiate or clarify there?
Sorry. These are photographs directly from Lance's phone.
How do you know that?
In Lance's first interview, he's showing the FBI agents these text messages, describes them to the agents, and at that time, his phone was photographed.
And you testified, I believe, yesterday that Mr. Twiggs' first interview was the morning of September 12th, 2025. Is that correct?
That's correct, yes.
Were you physically present at that interview?
No, I was not there.
Have you spoken with the officers or agents that were?
Yes, I've spoken to one of those agents that was there.
And you stated that first September 12th interview of Mr. Twiggs was recorded?
Yes, audio, video recorded.
Have you reviewed that recording?
Yes, I have.
So you stated that we're looking in State's Exhibit 16.1 at a picture of Mr. Twiggs' phone.
Yes.
Do you know who took these photos?
Yes, it was Agent Larson with FBI.
Did you speak with Agent Larson and confirm that?
I did.
And you kind of made reference to this already, but how did Mr. Twiggs initially show law enforcement the relevant text messages?
Yeah, during that first interview on September 12th, he physically, he shows them the phone and then allows them to photograph the phone.
And does he identify it as his phone in that interview?
Yes, he does.
Does he refer to any particular features of the phone that allows him to make that identification?
I believe the second interview he refers to the large crack in the upper left screen. That so he identifies that from his second interview that was given on April 20th.
And according to your review of the recording of his first interview and in speaking with the agents that were there, did he have his personal phone with him at the time of the September 12th interview?
Yes, he did.
And was this same text thread that we're seeing in State's Exhibit 16.1 shown to him during his second interview sorry, let me get the date right, April 20th, 2026 at the Utah County Attorney's Office that we just observed part of in State's Exhibit 16?
Yes, it was shown to him.
Was he asked how Tyler Robinson is saved in his phone, like as a contact?
Yeah, just as Tyler.
Without saying it, obviously, did he identify Tyler Robinson's phone number?
Yes, he did.
Did you check the number that Mr. Twiggs gave as Tyler Robinson's phone number against law enforcement records?
Yes, I did.
And do they match?
Yes, they match.
Is State's Exhibit 16.1 a fair and accurate representation of the text thread or the relevant text thread between Mr. Twiggs and Mr. Robinson?
Yes, it is.
As part of the investigation, was a Cellbrite extraction performed on Mr. Twiggs' phone?
Yes, it was.
Did you personally review that extraction?
Yes, I have.
And according to that extraction, did Mr. Robinson and Mr. Twiggs exchange text messages on September 10th through 11th, 2025?
Yes, they did.
What time was that first text sent according to the Cellbrite extraction?
The first text was September 10th at 11 p.m.
All right, Judge, I would move to admit State's Exhibit 16.1.
All right, so there we go. So that was kind of the essential, kind of foundational elements for the authentication part of those text messages. Obviously, there were some that Lance provided as well. But again, I made a chart here, so we're going to go down and kind of compare what was done in Sandoval versus what was done here and look at some potential shortcomings. Also want to look at this Cellbrite extraction. I gathered some information through ChatGPT about Cellbrite extractions. Again, I'm no expert on these forensic extractions, but we're going to take a look at that too and what these Cellbrite extractions can, what they can bring up or provide for investigators. And so let's take a look at this real quick. We're going to go through my outline and let's see. Okay. All right. All right. So here I have a nice, neat little chart. In all fairness, ChatGPT did help me put this together, right? So I uploaded the Sandoval case. Then I uploaded some other notes that I had made when I went through the video earlier that we just saw, which was Agent Davis's direct testimony regarding, and Lance Twiggs regarding the, basically everything that had to do with authenticating these text messages. But let's just go through this chart real quick. So in Sandoval, the detective who, was on the stand personally had viewed the phone. Here, obviously, Agent Davis testified that he had not, at least in regards to the pictures that are being introduced as the exhibit of the text messages, had not done so, that it was this FBI agent Larson who had actually been there to interview Lance initially and took pictures of the phone during that interview. In Sandoval, the detective personally photographed the text. Again, Agent Davis was not present when the photos were taken. He had testified that Agent Larson, not himself, had taken them. Okay, so here's a material. I mean, we could say material difference. A difference, right, is that in Sandoval, the detective actually photographed the contact page, right? Now, there was no testimony here that the contact page was photographed in part of the actual exhibit, right? Meaning that only thing that was in Exhibit 16.1, as far as I know, as far as I am aware, based upon the testimony and other evidence here, is that no, there was, the actual contact page listing, the picture, the contact. I think he has this Tyler Eckham or something like that, with Tyler's actual phone number. So that's a difference between what was introduced in Sandoval versus what was here. Again, going to authentication. The detective independently verified the phone number. So here we say that Davis did testify that he checked Tyler's number against a police database and it matched. But we don't know. Again, I'm very confused about what this database is. I mean, I don't know if they have a direct link with the cell company that would have that information. Hey, Penny, how you doing? Very nice to see you. So I'm not real sure exactly what he checked there in the police database. I'd be curious to know what exactly that was. Detective in Sandoval verified the dates and the timing. Like I said, because of when you take these pictures or check these texts the same week, you don't get like the calendar date on there. Here we have, according to Davis, they did a Cellbrite extraction, which later confirmed the dates and times. But again, I have it here, but let's go ahead and just go to the next one. The internal message content corroborated by sender. So in Sandoval, there was content within the actual messages themselves, which verified that the person sending it was actually sender. And again, I won't go over those specifically, but here the Cellbrite extraction. So, and we'll talk about this in a second, but it's my understanding that with Cellbrite, you can actually extract the information, meaning like the substance of the actual text as well. And so while it seems that there was a Cellbrite extraction, which later confirmed it was really just the date and times of the relative messages and not the actual content, meaning pulling that extraction out and making sure that the content of the extraction matches the content of the pictures of the text messages, right? Because what we're trying to do is confirm that the picture of these text messages indeed did come from Lance Twiggs' phone, okay? So again, I never heard that he actually printed out the content of the messages from the extraction and compared those with what we're seeing in the picture. Internal message content corroborates sender. So here, this was theoretically done through, I would say, Lance Twiggs and a bit through Davis's testimony. But basically, all I'm saying there is that references within the text messages themselves indicate that it is Tyler, right? So that would have been primarily done through Lance Twiggs' testimony in saying that, yeah, there's information here that Tyler is talking about that only him and I would have known. Okay. Obviously, there was some of that in Sandoval. Witness testified that the photograph, this was Sandoval, the witness testified that photographs accurately represented phone contents. Lance Twiggs here testified in Exhibit 16.1 fairly and accurately represented the relative text thread. Okay, so again, Lance Twiggs wasn't cross-examined. Agent Davis wasn't cross-examined, right? So yes, while Lance Twiggs stated that this fairly and accurately represented the relevant text thread, that was not, tested under cross-examinations. Just wanted to point that out. In Sandoval, the detective had firsthand knowledge of creating the exhibit, right? The pictures of the text messages. Here, Davis is largely relying on the agent's photograph, right? Another agent who he spoke with, this Larson, who testified, yeah, these pictures I'm handing you are ones that I took from Lance's phone during that first interview, this FBI agent. But Davis is saying that, again, that he verified it through the Cellbrite extraction review, but really just based on the dates and times of the messages. He didn't say that he actually compared the content of the messages from the Cellbrite extraction, right, with the actual content of the messages in the pictures that were being admitted here as Exhibit 16.1. Okay, so there are some, if we look at Sandoval as kind of the standard now, right, of what really needs to be there in order to at least on the front end authenticate these messages or authentication, it looks like there are some shortcomings here. And again, you could say primarily that's chalked up to the fact that Davis was not the one who photographed these messages, and that, he used the 1102 hearsay exception to bring in his discussion with Larson about it. Technically, that can be cured at trial if Larson shows up to testify. So just wanted to throw that out there as well. Here, GPT did a quick, lay of strength of the state's foundation. Tyler Robinson says, the state established Lance identified his phone. Lance identified Tyler's contact. Again, we didn't get a picture of the contact page from Lance's phone, which was present in Sandoval. Lance identified Tyler's phone number. It says Davis independently verified Tyler's number in the police database, but we don't know what that database is, where it got its information, right? Whereas in the Sandoval case, it said that there was a document in the county records where Sandoval had listed that cell phone number as his emergency contact, right? So again, we had more information in the Sandoval case than we do here. So maybe that's somewhat of a potential weakness, okay? Here it says the Cellbrite extraction confirmed that the text existed, but not the content. It didn't go into and say that the Cellbrite extraction matched the contents of the messages in the photos, right? So again, we have, the dates and times match it with these messages, but the content. So, again, is there room for manipulation in there? Sure. If the actual content of the messages aren't also being verified, when, as we'll read in a minute, I think that Cellbrite does have that capability. That might be something for the judge and or the jury to latch on coming up at the trial. Okay. Lance Twiggs did testify that the 16.1 is a fair and accurate representation. And yeah, so here, these are all legitimate Rule 901 factors. Okay. So here's GPT came up with some potential weaknesses compared with Sandoval. And I know I've talked about these already, but we'll just go through them real quick. One, Agent Davis lacked firsthand knowledge of the original photographs. He admitted he was not physically present, that it was a FBI agent who, and again, it says another here, but ChatGPT got that wrong. It's Davis is actually an SBI agent. That introduces an additional evidentiary link requiring reliance on another officer's actions, which again was allowable in the preliminary hearing because of the Rule 1102, Article 1, Section 12 paradigm there in Utah in regards to preliminary hearings. 2, again, the photographing agent did not testify, whereas the detective in Sandoval was the one who testified about the exhibit, the photographs. No testimony describing the actual process. Your notes do not indicate testimony about whether scrolling occurred, okay? Whether the photographs captured the complete conversation, whether screenshots were selected or omitted. And I know the ChatGPT is going off my outline. Thank you for being up front there, ChatGPT, but it's right. This information was not in the testimony either from my recollection. Or whether the images accurately reflected the phone at the moment they were taken. Okay, so again, Lance was asked whether whether that correctly represented the conversation, but wasn't asked whether the photographs actually reflected what his phone stated at the time they were. And again, I know that sounds like kind of minuscule or maybe petty a little bit, but it can be material in court cases. Okay. So Cellbrite came later. Unlike Sandoval, where the detective personally observed and photographed the messages before trial, here the Cellbrite extraction appears to function as later corroboration rather than the source of Exhibit 16.1 itself. But theoretically, it could have, right? And we're about to talk about Cellbrite extraction. It says, yes, a Cellbrite extraction can show the content of text messages, but the answer depends on the type of extraction performed and the condition of the phone. Now, we didn't get any particulars on exactly what type of Cellbrite extraction occurred Davis underwent, but here it says that this can occur. So, maybe we should have probably heard a little bit more information about that extraction. GPT goes on. Here's how it generally works. A logical extraction. A logical extraction retrieves data, and it's a Cellbrite extraction, retrieves data that is accessible through the phone's operating system. It commonly includes SMS text message content. Okay. I'm going to bold that. Text message content, iMessages, contact names and phone numbers, dates and timestamps, call logs, photos, and videos. So, I say that to say this is that literally they could have X-nayed the photographs, right? They literally could have X-nayed the photographs and just relied on a Cellbrite extraction. Right? So it makes you wonder, why did they not do that? Why did they rely on these photographs instead of just doing a straight up forensic extraction and relying solely on it? If indeed, like it's stated here, and again, this is just taking ChatGPT at its word. I don't think it would lie or have reason to be deceptive on a Cellbrite extraction, explaining it. They could have done the Cellbrite extraction. Instead, we have photos, app data to the extent acceptable. This is often sufficient to show the complete content of text conversations that still exist on the device. 2, a file system extraction. File system extraction goes deeper and may recover complete message databases, metadata, attachments, deleted records that have not yet been overwritten, additional app information. Good night, Miss Susan. God bless you. Love you. Have a good one. I'll be back in the next day or two with another live stream, so I hope to see you there. Says this is generally more comprehensive than a logical extraction. See you, Susan. Physical extraction. A physical extraction creates a bit-for-bit copy of the device's memory. Where supported, it may recover deleted text messages, deleted photos, deleted app data, other forensic artifacts not visible to the user. Modern iPhones with full disk encryption often limit the availability of true physical extractions depending on the model, iOS version, and whether the device is unlocked. What a Cellbrite report typically shows, okay? See you, Susan. God bless. A Cellbrite report usually contains the actual text message content, right? So again, let's read through this and I hope y'all understand that, they could have just used the Cellbrite report, right? Just could have used the actual forensic report. The actual text message content, the sender and recipient phone number, date and timestamps, whether the message was incoming or outgoing, attachments, photo, videos, documents, conversation threads. In many cases, the report displays the messages in a conversation format similar to what happens on the phone, right? So this means that, or I'm taking this to mean that, it would have even looked like a common text message thread from the Cellbrite extraction, right? So like they wouldn't have lost any of the intended effect of like showing this as a conversation, right? So again, we have to ask ourselves, I can say this, if I'm a juror, I would rather see that. I would find it more official and believable to have that Cellbrite extraction than a photo of a phone with a cracked screen, right? So just on that fact alone, I would have, if I were the prosecutor here, I would have just run with the Cellbrite extraction. And that would have cut down on a lot of the back and forth testimony with Lance Twiggs and Davis. It would, again, I won't go through the whole workup there, but it would have just been, hey, we seized this phone from Lance Twiggs. We ran this extraction on this date, this time. This is the methodology, XYZ. This is what we got. You see what I mean? But again, would have been a more official, in my opinion, rendition and piece of evidence to offer than the photographs. So we have to ask ourselves, why did they go with the photographs still? Let's see. Why this matters in the Tyler Robinson analysis. Based on her notes, Agent Davis testified a Cellbrite extraction was performed on Lance Twiggs' phone. Now, we have to also ask ourselves, right? Now, they had a search warrant for Tyler Robinson's phone, and indeed did seize Tyler Robinson's phone, and indeed did do an extraction on Tyler Robinson's phone. So you got to ask, why wasn't pictures from his phone showing on his phone the same thing, and or a Cellbrite extraction showing also the same message content? Why wasn't that also offered, right? Might judge require that at trial to meet that initial, right? That initial showing of authentication. If I'm going in front of a jury with this stuff, especially with as incredible as the content of these messages are, meaning that, I don't know, maybe 8 or 9 out of 10 people I talk to that know anything about this case, that read those messages, say that doesn't seem, with the largest caliber, right? It certainly sounds like your friend from down under, Rick, and God, I love you. That isn't a derogatory, but obviously the Agent Hole, who's from down under with the caliber. The other day I was sitting here in the morning with Special Forces Mike, just laughing. Like I could just see, Agent Hole there drinking wine with another agent, laughing as they make up those messages with the caliber, the CALIBRE, right? Like, come on now. And, I think in there also to say something about a rifle hunt. I've never heard anyone in the U.S. say, refer to any kind of hunt as a rifle hunt, right? It's usually like deer hunting, moose hunting, elk hunting, duck hunting. Never, we're going on the rifle hunt. Again, so with that being said, with as much doubt has been cast on these messages, just the substance of them, man, I would have not only just used the Cellbrite extraction, I would have also included the extraction from Tyler's phone, showing that I would presume, hope they're an exact match, right? And then all the other evidence used to like work those up. But, that could be done simply by the agents, right? You wouldn't need Lance Twiggs to work that up, right? It could be done with the agents if there's a warrant that was gotten and then done the extraction, et cetera, et cetera. So that's what I would do with all the doubt that's been cast upon this. But anyways, Davis testified to Cellbrite extraction was performed on Lance Twiggs' phone. He personally reviewed the extraction. The extraction showed Robinson and Lance exchanged text messages on September 10th through 11th, 2025. And he testified to the time the first message was sent, right? And then he also testified that the last message was sent, according to him, at about, I think, like 7. So it seemed that it was like right before that Discord message, that 7:57 or allegedly 7:57 Discord message was posted. But again, just very suspicious circumstance there, if you ask me. But it goes, if that's accurate, then the Cellbrite extraction is independent forensic evidence confirming that text messages existed between those two devices at those times. It is stronger evidence than merely relying on photographs of the phone screen. It certainly is. But I think in a way, like I've said, it really also undercuts just using the photographs, right? Because according to here, you can get the actual content of text messages through the extraction. So with that being said, I think the Cellbrite, at least as it regards to a jury, now it might not affect judges, judge at trial wanting to let it in on the front end, but I think it could undercut. I would tell the jury, it's funny that they have the Cellbrite extraction that has the capability of actually just extracting these directly from the phone, yet they're showing you pictures of it. Why is that? Why is that, right? Why are they relying on these pictures when a more official forensic data extraction can show you the content of those messages? And moreover, that they could also pull that same extraction from Tyler's phone and show you an exact match, right? Show you an exact match. And now ultimately too, let's never forget this, that as far as I'm aware, they don't have any testimony of someone seeing Tyler messaging on his phone at this time. So that's always something that we must remember. And also, depending on what time it's ultimately found he was taken into custody, he might not have been in any position to send some of those text messages like the Discord message. Now, I'm not going to go into all that tonight, right? But just understand, I think everybody that's been here with me for quite some time knows that, yeah, there's doubts as to whether he could have sent that Discord confession. Well, depending on what time he turned himself in on the 11th, he might not have even been in a position as well to send some of those text messages. And the other ones, I don't think there's evidence of a witness or that saw him texting on that phone at that time, right? So again, still there are holes, right? There are doubts. There's quite a bit, if you ask me, that even though these might get through judge at trial, I don't know if the jury's going to buy it on the full authentication question. Let's see. However, there are still important questions, right? Did the Cellbrite extraction itself contain the exact messages shown in Exhibit 16.1, right? That's what I'm saying. Like, did they include, is that an exact match with what the forensic data extraction would say? Okay. Was Exhibit 16.1 created from the Cellbrite report or from photographs taken during Lance's first interview? Well, they claim from photographs taken during Lance's first interview. Did anyone testify that 16.1, the exhibit, was compared line by line against Cellbrite extraction to confirm they were identical? No, they did not. Right? No, they did not. Date and time, yeah, they say that was, but not the actual content of the messages themselves. Was the Cellbrite report itself admitted into evidence or only used as a basis for Agent Davis' testimony? To the best of my knowledge, let me look this up. Maybe Ian's. Give me just 1 second. Maybe Ian's thing here can tell me. Let's look. Let's see. Oh, damn. Let's see. Let me see real quick. Okay, here we go. see what it says. Okay, it says here no. And let me just pull this up for y'all real quick. So I wanna support Ian's thing here, even though the videos were kind of having a hard time playing here. Let me show y'all what I put here, just so y'all can see. And let me do this. Then go to. So I put did the state enter the McBride extraction report of the messages from Lance Twiggs' phone into evidence in addition to the messages themselves in Exhibit 16.1? It says the answer is clear from the record. No, the state did not enter the McBride extraction report itself into evidence as a separate exhibit. Here's what the documents show. State Exhibit 16.1 described on the state's own witness exhibit list as text messages between Ty Robinson and Lance Twiggs. A photo-based exhibit, Bates number 54, disclosed on October 24, 2025. Yeah. So, yeah, I'm not going to go through all this, dude, but you can see how detailed this tool is. This is incredible. But anyways, just wanted to share that with y'all. Let me go back to my outline here, and we'll work towards finishing up this live stream. Let's see. Let's see. All right. There we go. Okay, back to where we were. Yeah, so again, we just looked. And so, yeah, the McBride extraction was not entered into evidence, although it was mentioned as, something Agent Davis used to corroborate the text message, the photos of the text messages. Again, I think that it's kind of suspicious with that. Here it says these distinctions matter if Exhibit 16.1 was based on photographs taken during the first interview. The McBride extraction can corroborate the existence and timing of the message, but it does not automatically establish that the exhibit is a complete and accurate reproduction unless someone testified to that comparison. It says, for your live stream, one of the most useful questions to explore is whether the state established that the exhibit shown to the court accurately reflected the contents of the McBride extraction, or whether the extraction merely confirmed that some messages existed between the party. That distinction goes directly to the strength of the authentication foundation. So, anyways, man, I have a toothache. Y'all, give me just 1 second. I have a toothache. I'm going to grab some BC powder real quick. Give me just 1 second. Hey, Papa. Oh, man. Hey, Papa. Okay, my apologies. So, yeah, so we're going to wrap it up now a little bit. So, kind of, let me get this. So I got to do that. Woo, that is not good stuff. The BC powder. Man, that's bitter. Oh. It's kind of rough, but feeling a bit better. Anyways, so like I say, there are some issues. I mean, again, they did the best they could, I take it, with what they had there. But I want to tell you that my ultimate opinion is this. Oh, yeah, I did. Yeah, it was kind of up here, my upper jaw. Thank y'all for the pointers, though. I do appreciate it. I will say, and I'm sorry to digress for a second, but I did have a bad toothache down here for a while, and I would drop the BC powder directly on top of it. But I had the flavored ones. I'm gonna go get those next. And yeah, it did. It helped. But thank y'all for the concern. I do appreciate it. Anyways, obviously there was enough at this preliminary hearing for judge to allow those text messages in exhibit 16.1. Now judge will go back, and to the extent that the authenticity of those text messages is going to bear on his determination of probable cause, which, let's be honest, as I've said for a long time, their case is very reliant on those text messages, right? Their case is heavily dependent on the authenticity of those text messages. Okay. Now, but when we get closer to trial, this motion in limine is going to be a little bit different story in that, they're going to have to meet all those requirements, meaning that, Agent Larson more likely than not is going to need to come up there and testify about these photographs. But if I'm the defense, I'm going to be pointing out that, Judge, they did a Cellbrite forensic extraction that should have also included the actual substance of those text messages. So at this juncture, Judge, why are we relying on a photograph of these text messages? So I hope y'all understand that. So so at that point, most definitely, because again, the rules of evidence very relaxed at these preliminary hearings. So sure, using this photograph with Lance Twiggs Davis' testimony, unchallenged testimony of Davis, right? Sure, they can definitely get away with it there, as they did. That was receiving the evidence. But if I'm the defense, I'm filing a motion in limine pre-trial and challenging them to produce that Cellbrite report showing not only the dates and times. He testified that those two things match up. Well, I would argue when we're getting to trial that, they need to pony up and produce that report. They at the very least need to produce that report to show, as he testified here, that those things match up, that the date and times match up to the photographs, right? And also, again, I would go further that they need to also produce and to show that the content of those things match up. And ultimately, if this ends up being admitted and goes to a jury, I would argue to the jury, I would say, well, they also had Tyler's phone and did an extraction. Man, it would have been nice for y'all to also see on the second end, right? I would say, look, these messages look weird, right? Well, Agent Hole with the caliber and the rifle hunt, these things are weird. That's what I argue to the jury. I would at least insinuate, again, my opinion, allegedly, that, this Agent Hole, it looks like that dude at least wrote some of this. It looks like that dude probably wrote some of this, and then I would just suggest to the jury, it's funny that they, let them think just those photographs in at trial, right? I'm going to go up there and I'm going to tell a jury, man, this is business. It's funny business right here. This is a really funny business. One, they did a Cellbrite extraction, forensic data extraction, which could show you, verify all these dates and times, and it could also verify the content. Where the hell is that? Okay. But look, these funny messages, I would imagine that y'all are also craving for some more verification beyond that, and they could give it to you. They could also give you the one that they took from Tyler's phone, and those two things should mirror one another. And in that instance, the jury, I would tell a jury, you should demand the highest standard in provability here, right? That they could produce these official forensic data extraction reports that show, from the data extracted, that these two phones have the matching date and time and substantive messages, stamps. Bam. And, with that, it would cut out a lot of this other BS testimony from Lance Twiggs, et cetera, et cetera. So anyways, even though these messages came in, ladies and gentlemen, I just want to reiterate to you that, there are still issues with, their authenticity and with their ability to, prove those up both initially to judge at trial. I'll venture to say that judge is probably going to require more than what they produced here to let those in at trial. And I certainly believe that a jury is going to hold them to a higher standard and require more before they're going to be able to get them to have a finding that those are actually indeed authentic. Okay. I hope that helped. I hope y'all enjoyed this live stream. I hope you got something out of it. I'm going to, and Ian's platform, I hate that the videos didn't show, but I guess y'all saw that's pretty cool, right? Where it's like, it did the analysis for me. Like, it's just like, it's kind of like Chat GPT, except it's got all the Tyler Robinson stuff in it. And then the footnotes where you could just push it and it pulls the transcript up below and then pulls the video excerpt up above, man. I hate that it didn't load like it was. I'll try to figure that out, but man, that is cool. I can say right now, thank you, Daisy. I appreciate it. I can say right now, ladies and gentlemen, that my stream quality and content quality is going to increase because of that thing right there. So thank you to Ian Carroll for that. God bless you for all the hard work that y'all put into that. From everything I can see right now, it's worth every penny for content creators like me and Adam and these others to put into that. So thank you, thank you, thank you. Let me check some comments real quick before I get off here. So yeah, let's see. Check some comments and and then we'll get y'all out of here in just a minute. God bless y'all. Thank y'all for your support and love. I love each and every one of you. It's been an incredible journey with y'all. I don't know if Adam's here right now, but Adam, love you too, brother. God bless. The Chi girl. Is that a husky? Oh no, that's a Chihuahua. Oh, the Chi girl. I guess that's Chihuahua. I have a husky, love. So when I was looking at that little bit, I thought, is that a husky pup? Because we have husky pups here and I love them. I like Chihuahuas too. I love the dogs too. They're cute too. But they just couldn't bring themselves to swipe left on that phone to give us the times. Yeah, again, while this might have gone over in the preliminary hearing where the rules of evidence are relaxed, I don't think that's going to fly at trial fully, right? And even if they're let in, again, me as a defense lawyer, I'm thinking, okay, the content of those messages themselves is weird, right? So obviously at trial, I'm going to, and here's one thing, let me say this, not, cross-examining Agent Davis is like, when you're at these preliminary hearings, that testimony that Agent Davis gave can be used against him at trial if he switches up, right? And so while, his direct testimony, same thing, and he was, examined on direct by the state, you at the very least could have produced even more testimony and tripped him up on key things, right? Or at least made him, put his feet down on key things to where if you go to trial and tries to switch up on you, you can nail him, but you just let all that go. So beyond, them being able to cross-examine Lance, cross-examine Agent Davis at the trial, they also too can bring up this Cellbrite extraction and the fact that the jury not seeing those actual extraction reports mixed with the very suspicious circumstances or of the content, right? The very suspicious content of those messages mixed with, I'm sure, some punches and jabs. Hopefully they would get on cross at trial. I think that they could easily have a jury say that, this is just not good enough for us to find those things authentic and hold them against Tyler. See what I mean? And again, I think that the state's case is very much largely dependent on those text messages, right? Because we don't have the confession from the parents. They're not testifying, obviously. So the only other confession, is alleged. And I think too, y'all, Lance is going to testify that Tyler, magically, we have a new confession now to Lance Twiggs in this second statement that he gave. And I think that's an ultimate contingency because they know that the text messages too might not be relied upon, right? The jury might find those things inauthentic. And to the extent they do, they still need some kind of confession. So now they've gone to the third option of having Lance admit to one, right? That's just my viewer perspective on that situation, right? Here goes basic niche. That wow, man, the truth. That would be so wild if it was really up to Hole and one other dude to craft the text. Someone had to do it though. But yeah, imagine Hole being the stand, knowing what he did. I mean, correct me if I'm wrong. Barron did a good job pointing out the caliber. The caliber, the Australian voice, the caliber of the rifle hunt. Yeah, dude, those two little parts there make me think that this whole dude might have been either solely or in conjunction with another agent or a couple agents involved. Special Forces Mike told me his impression is that Hole and then Davis are actually intelligence people who were actually brought in to kind of commandeer all this, and that, you know, they were overseeing all that stuff be dropped. Again, allegedly, our opinion, but just wanted to bring that up. But yeah, man, that's kind of crazy, isn't it? Let's see. So Chi Girl says, I still think the messages read like Twiggs is being coached. Yeah, I think that's a fair assessment too. But again, I think the main takeaway from that, though, right, is that not just Twiggs himself, it's some law enforcement coaching, right? Some law enforcement. And a matter of fact, I think Lance Twiggs is part of law enforcement. I think he's part of either law enforcement or intelligence. That's just my take, my read on him. Definitely not a person that has been transitioning within the recent past, within the last year, right? Like, I don't think that person has ever been anything transitioned. Obviously, I don't think he's what people would consider, and I hate these kind of like alpha male, but he definitely ain't somebody that's transitioned. All right, that person has not manipulated their hormones towards the estrogenic side, in my opinion, in any way. So there you go. And, you know, my opinion now on the photos of him with the furry, with the quote unquote furry, I said furry, with the animal hat and pajamas on and a little bit of makeup, was something that was just a show, something done to set this up, my opinion, allegedly. Okay. Not saying that's absolutely what it was, but that's just my opinion, my read on the situation. Let me know what y'all think in the comments. Let's see here. Let's see. Rick says Hole. I think he's put Hole. I think he meant Hole. Won't have a job tomorrow, being a investigation amongst police officers. Oh, so you're saying being investigated, like actual the police being investigated. I sure hope they get investigated. I hope they do. Robert, you're right. A 30-06 would have taken the head off. Did I show y'all? Let me show y'all something real quick while we're here. I wanted to show this on the live stream I was on Friday, but we were having trouble. And I enjoyed that live stream, by the way. I'm going to try to do another one, I think in the next week or so with them as well. Let me show y'all this. Here we go. So let me show this real quick. So this is Chris Martinson from Peak Prosperity. Yeah, look. Oh, hold on. Sorry. Okay, so y'all see this right here? That's a 30-06 that he's shooting this ballistic gel with. Okay, right? And that is, I believe that's the entrance hole. I believe that is the entrance wound. Okay. And let me actually back it up here for you. Look at that. Look at that. Y'all see that? That is the entrance wound, right? From a 30-06 in ballistic gel. Okay. We didn't see that. All right. We did not see that. So I hope y'all can see that okay. But yeah, we did not see that. Okay. So just to give you an indication, and then you could just your own mind work it out to see what that would look like with an actual human body. Right? Not pretty. Like Basic says here. For sure, Robert. Completely ludicrous proposition. It would have been a horror show under that tent. I agree. She says that woman who was first on, she had only done testing once before and didn't remember when. Yeah, it's probably because she might have been pulled in to play that part and not necessarily right. And the pictures of the note should raise red flags. Yeah. And the whole story with the note should raise red flags. None of that makes sense, man. None of it makes sense. Like, why would you take a cell phone picture of a note that you destroy? You know, kind of defeats the purpose, huh? Kind of like in the messages where Tyler admits to everything he's doing, but wanted to keep it just to himself until he died of old age, right? No sense. Oh, yeah. So I can't imagine being in a sheriff's office, Fender Police Department, sitting there texting, or especially after you've invoked your right to counsel, especially when you have an IQ as much as his to know, and undoubtedly should know better. Let's see. Here we go. Basic. Always heard the cliche, a war is going on for your mind, but for real, the deep state is devious as fuck. Yeah. Yeah, man. Yeah. And yeah, I'm learning more and more. Special Forces Mike and I are sitting here every day working out these psyops, and yeah, man, for real. It's for real. It is a war. And this, I think what we're seeing here in the Charlie Kirk incident is ground zero. So, for me, the way I see this is like this can either be something that destroys us, or it could be something that I think has been bringing us together and a learning opportunity. And I'm learning just as much as y'all are. Okay. I'm obviously got some legal knowledge that I'm bringing to the table to like analyze this court case, but I think y'all can see that like what I'm trying to do is help. And again, this is helping me as much as helping y'all like uncover this op. Okay. Because we can say what normal legal process, procedure, substantive law should be and how it should play out. And when we're seeing these deviations, it's telling me stuff. Okay. And I hope that y'all are getting the same from it. It's a good idea, Basic Niche. We need a definitive red flag list to compile. It's getting so long at this point. Yeah, we do. And maybe I'll start working on something like that. Very good idea. Yeah, man. Spyglass, good to see you. Good to see you. A law enforcement database may contain phone number from any contact with law enforcement, like a car accident report ticket. Okay, that makes sense. But still, it's like, okay, I wish that they would have said, we searched the database. This is the document that we're the reference that we found in an accident report from 2022 or whatever. As a matter of fact, I've seen pictures of Tyler Robinson, or actually as a body cam video of Tyler Robinson from a car accident that he was in. Is that report where you got it? I would like to know that. I think a jury would too. I think a judge should want that. Debbie, Ham and Adam, I worry about them taking those powders. That's hard on the stomach. It is. I don't take a bunch, Debbie. I don't. My wife and I keep them around here because she gets pretty bad migraines from time to time, and they really help her very quickly. I've maybe taken 2 or 3 this week, just because of this toothache's popping up every now and then. Let's see. Cowgirl, how convenient that Tyler never looked at any cameras, almost like whoever that was on camera knew not to look up, hiding under that hat like a paid actor. Surely not. Surely not. Let's see. Hey, Rick, if you can, if you're here, brother, like comment and let me know, like I asked you, those terms, like obviously caliber is a European and I'm sure an Australian way to say caliber, as we CALIBER here. But I think in there too, it also says rifle hunt. Okay. So that's not something I hear in the US. Okay. Is that something that they say in Australia? I'm just trying to connect that some of that language in those texts might be indicative of something that Agent Hull as an Australian might have cooked up. Let me know your thoughts on that, Rick, if you can, before we close down here in a minute. No rush, no pressure. Oh, I'm going to see a dentist raining. I do have a dentist up the road here, and they're really good. I mean, as a lawyer, I do a lot of public interest work, so I don't have a lot of money or insurance. But they, it's great. These rural clinics out here do a pay scale. So yeah, I will try to set me an appointment and have them go look at it. Thank you for the concern. Thank you. God bless. Let's see. That's a good question. Do you think the defense will run their own independent self-extraction? I mean, I would sure hope so. I would hope that they already had. And, I would have hoped that they would have cross-examined Davis. But they didn't, right? And so they could have just have even simply as asked him, like, well, why didn't y'all attach the extraction to this exhibit? Right? So, yeah. Oh, thank y'all for the kind words on the stream. Thank you, Rick. Thank you, everybody. I appreciate that. I threw it together today, and to be quite honest, like I say, I suspect the quality of my streams will even get better from here with Ian's tool, man. That's incredible. Now I won't have to spend as much, like if we're going to go back and talk about this preliminary hearing, I won't have to spend as much time going back and reviewing to get timestamps and stuff like that. Like it pulls it up for you automatically, man. That is a huge help. Thank you, Spyglass. I appreciate it. God bless you. Well, anyways, y'all, I think I'm about the end of my road tonight, but I wanted to show y'all something real quick where I go. Come here, bud. Thank you. I want to show y'all a little ham here. Little ham. Little buddy. I'm about to take him out, and then we're gonna go to bed, y'all. Just want to say good night. I love y'all. Thank y'all. Buddy says bye, y'all. Bye. We love you. We love you. Anyways, yeah, I will be back here in the next day or two with another stream. Let me know if anything in the comments out here once the video posts. Thank y'all again for all the support, man. Much love, and I will be in touch. I'll see y'all soon. Peace.